Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Oh my god, it's Reseller Road Trip Adventures' birthday! Oh, I'm searching my memory for your name. You'll have to remind me and I feel terrible. But Reseller Road Trip Adventures is going to be tough to hit properly in my happy birthday song. Oh, I feel like it starts with an L. Maybe I'm probably wrong, but oh, Josie! Damn it, Paisley. Josie. Remember the movie Josie and the Pussycats? I do. Paisley remembers Josie and the Pussycats. Is it Josie or Josie? I think I would call you Josie. Both work? All right. Well, give me a minute. I just want to point out, hi, Rose. Why is my cup all fucky? Hold on. I'll hold it here and then. Oh, the light is very bright. I forgot. It's early. It's morning time, and that means I have double light because the natural light is lighting me, but I also always put on my light. Anyways, you can't really see it. That's full of ice, and then I put in my milk, but my milk froze in the fridge. I think I might be keeping my fridge too cold. Hi, Naybell. Anyways, so I'm gonna have my iced coffee here. Oh my god. Well, it's mostly milk, really, but we're gonna continue on with that. Oh yes, that's a glorious thing. I've never been one to buy iced coffees out of the house. I'm just not. I like hot coffee out of the house. But since I've not been buying anything out of the house really, and trying to like make my own drinks, so I know how much sugar is in it, and because apparently cutting out Coca-Cola, you get a lot more calories allowed. Anyways, so I'm excited for my first sip, which is basically like half a cup. Anyways, so happy birthday to Josie. Let me sing to you. Happy birthday to you. Happy birthday to you. Happy birthday, dear Josie. Happy birthday to you. I hope you have a really great day. July 31st. What a day for a birthday. Why are you fucking up? Can you stop it, green screen? Thank you. Sorry. Love-hate relationship with the green screen. Office is moving soon, you guys. In the next week and a half, I will have to take a day or two off because my whole studio will be moving. Yeah, from Jackie to Josie. My whole studio will be moving, and we will be recommencing in a new location. Same house, just a different studio. We're shuffling things around here. There will be no natural light. I'm probably going to have to invest in some more lights. But there will be... It'll be fine. Whatever. We're not going to dwell. We're not dwelling. No, Jackie is what AI calls me. Oh, you're going live. That's awesome. Oh, I'll try and pop by. I'm working today. 5 p.m. Arizona time. Is that the same as Pacific? No, because you don't do daylight savings time in Arizona, if I recall correctly. IIRC. So that means you're probably an hour different than me. It's 9:52 a.m. right now. Are you at 8:52 a.m. or are you at 10:52 a.m.? Those are my guesses. Anyways, yeah. Let's watch some court. 9:50. Oh, so it's Pacific time. It's the standard right now, I guess. So we're the same. 9:52, baby. I switched a load of laundry. Oh my god, you guys, I have to tell you this. I'm terrible at folding laundry and like putting it away. I just don't see the point. But then recently it was pointed out to me that I have a lot of clothes and they, you know, sometimes it's easier to see them when they are hung up in a closet or something like that, as opposed to perhaps I'll be kind and say strewn instead of strewn about. Yeah. Anyways, so yes, I have way too many clothes, but today I hung up like 15 dresses that were from the laundry. Yeah, somebody's bad-mouthing the clothes pile, basically. And here's the thing. When my kid was younger, I say kid, I was going to say my kids, because at the time there was 2 kids in the house. Weirdly enough, the same 2 kids that there are now going to be in the house, but they're teenagers now. But when they were little, we had we called it the middle room. It was just a living room in between the living room and our bedroom, like the adult's bedroom. And it also had a laundry room off of it. Oh! A year of your life wasted, but well wasted, baby. Thank you for being here. Thank you for 12 months support. Anyways, I'm telling this story because this room was quite large and the laundry room was right there, and we developed a really good system, but the system did involve piles on the floor. Like, it was like in nobody's imagination is Paisley folding every fucking person's laundry. Like, no. It's just not happening. So, it became a dirty, clean basket pile situation, and it worked out well, you know? It works for me. It's worked for me my whole life. My family hates it. Not my family, but my Nana. Nana, I think, enjoys folding laundry. I guess that's all I can really think of, because otherwise, like, why? Why? Anyways. Black for dirty, white for clean. That's smart. I have now the laundry is down the stairs, but so will be my studio down the stairs. And so we'll see how that goes. Regardless, we're not thinking about that right now. Like I said, we're going to watch some court. We actually have to get going 8 minutes in because this is an hour-long hearing, and we're going to watch it. I think we've seen these people before. Oh, Hundy P reseller. Hundy P. Also, my ADHD dictates that sometimes I will re-wash the same load multiple times just to not deal with it. It's the same as, like, I don't know why I've overcome this in this house, but every house before, and I imagine it's just because, like, I didn't know where the things went, but there was, like, a difficult dish that would be stuck in the dishwasher for like 3 loads because I didn't want to deal with putting it away. And so instead of putting it away, I would just leave it in the dishwasher and rewash it again and again and again until I decided to decide where to put it. In this house, I've got a better handle on things in terms of where they're located. And so I do the load of dishes like every single day. But that's literally what I used to do. And laundry, the same thing. You leave it in there, you're like, fuck, it's been in there, has it been in there too long? May as well do a quick one. Just a little quickie. Quickie. Also, MB, I hope you're doing okay. Please be well, my darling MB. I hope you're relaxing. Don't drink out of any straws like I am. I know that's bad after dental surgery. And, yeah. Holy fuck. In my. I guess I have been up for quite a while because I managed to record all this damn court. I was like, how did I manage to record 80 minutes of court this morning already? It's not even 10 o'clock. Not even 10 o'clock! I'm a hoarder. Yes, be well, MB, please.
Petitioner appears in Ms. Locke's office. The respondent appears with her counsel, Mr. Olson, in his office. All right, so this case is back in front of me on a motion to modify custody. Correct, Mr. Olson?
Yes, ma'am.
All right. Well, I'm still, I've got to find that any modification of custody is in the child's best interest. There is a question about this case meeting any kind of threshold prima facie level. I'm not sure about the material change of circumstances. Have to look at that again, but last I checked, it required essentially, or there's an argument that it requires full custody litigation in an evidentiary trial format for it to apply, which I think is a little silly, but that's what I thought we determined today. But I think there were some exhibits that were presented a little late for Ms. Locke to really, in all fairness, have a chance to review. I will tell you where I'm at, counsel. This is where I am on this case. I am inclined, and I'm not prejudging the case, but I am inclined to send these two back to Paula Langworthy and have her go through the very detailed parenting plan that she worked up with them and see if there have been any genuine violations of that plan in any significant regard, and hear from the parties and give the court an opinion as to whether or not she believes that there's been any kind of change of circumstances that would warrant reconsideration by the court.
Yeah, so if this is starting to sound familiar, it's because we have heard this part of these cases before. These parents are litigating. Look, their lawyers loving it. Also, I fixed the green screen. Yeah, fuck you, green screen. Turns out you really have to change your chroma key in the daytime because the colors are all different. Anyways. Hi, Casey Carey. Yeah, snooty parents. Why in the fuck you would be arguing like this with lawyers is beyond me. Some of these people just need to either move on or I don't even know. I don't know because... And also, Cellulite Yoga Pants, I'm so jealous of how organized I imagine you are. I wish I could be that organized, but I am not always that good. sometimes I am. Like, sometimes I get a burst of whatever and then things get organized for a little while, but, you know, it's not the top of my priority list to put away clean clothes. The fact that there's clean clothes to me is like, oh, we've won. We've won.
That's what I'd like to do. Because there are a lot of allegations here. And I think that you have to take each allegation. I think you have to look at it in light of the parenting plan. And then I think you have to hear from each side. And then I think you have to determine whether or not there is an actual breach of anything. And as far as the child's concerned, she's not old enough to give input. I will tell you the other thing I'm concerned about, Mr. Olson, is a lot of these issues she's raised are really pretty re judicata. As previous matters.
Re adjudicata, I think that means already adjudicated, or like the things that have. Is that right? I'm gonna have to look that up. Because I think that I love it when Southern judges drop Latin. Res judicata is a legal principle often referred to as claim preclusion in the U.S. that prevents a party from relitigating a claim or issue that has already been decided by the court. It's a Latin term that means a matter judged, i.e., no second bite at the apple. You can't just keep going before different courts until you get what you want. Right? Right?
That were brought up prior to the final divorce settlement. They may or may not have been fully litigated, but their complaints that were on file with the court and have been voiced by her numerous times. So the only thing that I am not sure of that I would have to very carefully examine, I'm not sure I've ever seen, I don't know if it's in these exhibits, is there have been allegations that he's purchasing liquor, and that after the trial was over, she got to go through some of his finances and discovered that. That may be the only new information that she didn't have a chance to bring forward or produce. But that's where my thought process is at. But I'll let you respond, Mr. Olson, and then Ms. Locke.
Yes, ma'am. I would tend to agree, Your Honor, unless the court is wanting me to. I'm not going to go through the itemization of I think our 17-page motion to modify. There's also been a couple of responsive pleadings filed with respect to that. So obviously the court can read those if it feels the need. I would say a couple of things, Your Honor. The court is right. These parties did go, and there may be a couple of things I'm not absolutely precise on as well, Your Honor, because I didn't get involved in this case until later on, where a lot of this or some of this litigation had already occurred, so I wasn't present at the time, which as the court I know well knows, always makes it a little bit difficult. But regardless, these parties, as the court knows, went to see Ms. Langworthy last year, and there was an agreement reached on August 1st of 2024 that adopted Ms. Langworthy's recommendation. As part of that recommendation, there are a couple of aspects to it that I think are very important for the context of this hearing here this morning, and that is Ms. Langworthy put in there that if the petitioner has one positive alcohol breathalyzer, one positive alcohol result, that the respondent should be allowed to go pick up the minor child, even if it's during the petitioner's parenting time, and keep the child until such time as his next parenting time starts, and then he shows that there's been a negative a breathalyzer test. It was something that was in place during the pendency of this case and was contemplated by Ms. Langworthy's recommendation, Your Honor, that there would be an ignition interlock device attached to the petitioner's vehicle. He has also at times done handheld breath tests and sent videos to my client prior to his parenting time. As the court all knows, there's been issues with alcohol throughout the duration. Again, understanding these according to my client, but alcohol abuse by the petitioner, allegations of that, I believe. That petitioner's position has been is he's been sober since November of 2002. So fast forward, we get to August 1st, 2024, where this agreement is reached. At that time, the information that we have provided through either these bank statements and or these breathalyzer tests for the ignition interlock device that was attached to one of the vehicles that the petitioner drives, none of those were available to the respondent, nor had they been requested. That agreement was reached August 1st, 2024. We moved on. There was a pre-trial date, I think, that we all had, but this time I was involved in the case. Again, this is where things get a little fuzzy. There's a point to this, so I'm not trying to waste time.
Nobody can ever say you didn't try cellulite yoga pants. I don't mean to laugh. It's not funny. But I love it's love. I mean, you're obviously trying. And I hate that he does that, but I have to admit that I used to also get fast food by myself sometimes. And then come home, but I wouldn't eat dinner. Would I eat the dinner? I don't know. Terrible.
The court had made some pretty cut and dry orders. Sometime, I think either that August date or a subsequent date before I got involved, the discovery was closed, so on and so forth. So we got to, I believe, either a status conference or another pre-trial conference here in Ryan. At that point, got involved. And we had requested through some business record subpoenas to ask for and be allowed to issue those subpoenas with respect to these bank statements that we've provided, as well as these ignition interlock device readings. The court allowed us to issue those, but I believe that was not done until roughly November or December of 2024. At that time, we had already had a trial scheduled.
Yes, and there are some foods that are naturally low in salt and fats. Like, for example, there are some cheeses that are actually made to be low fat, low salt, but then Swiss cheese is very naturally low in fat, and salt especially. So if you're trying to do a low sodium diet, you can get real like Swiss cheese and it tastes really good, but it's actually on the healthier side. I sound like a cheese pusher, and I am.
For January 25th and 26th, or 26th and 27th, and whatnot. And the court, who had already believed the trial date had already been continued once or twice before my involvement, had said, and I completely understand, hey, we're going to trial in January. If you want to issue these additional subpoenas and get this information, that's very fine and well. I'll allow you to do it, but we're not going to move the trial date. So long and short, that information was not received back by the time the parties got to trial. We had a trial date. We were able to settle the outstanding financial issues that the parties had. We did not address anything at the trial agreement relating to residency parenting time, because the understanding was that on August 1st, that had been agreed to in the Paul Langworthy's recommendation had been adopted, but for maybe some child support and health insurance benefit stuff that was contemplated in the journal entry judgment decree, of course. So why I say that is because, as the court has noted, there are bank statements and two breathalyzer readings that are of pretty decent concern in my book, that have shown that petitioner, although that he has represented to the court that he's been sober since November of 2022, has still continued to purchase alcohol. There are two breathalyzer readings, one from October and one from November, that show that, make sure I've got the readings right. On October 1st of 2024 at 6:53 in the morning, he registered a .068 on his interlock device in the vehicle. And then on November 4th of 2024, he registered a 032 at 7:13 a.m. on that interlock device. There are no readings after November because I believe the petitioner quit using it, even though that was also part of Ms. Langworthy's recommendation. That I believe once the recommendation was adopted, petitioner was to keep that ignition interlock device on his vehicle for 6 months. And he didn't have any readings in December. And why I mentioned December particularly is because of, at least from the statements we provided, there were 4 dates between the two bank accounts that through Bank of America that were provided, 4 times where petitioner purchased alcohol. It's clear cut. It's
Your Honor,
Your Honor, actually, I need to step in here. First of all, MB, I love you so much. Sending PPs while impaired, though, I can't recommend, but I do appreciate. Thank you so much. Seriously, thank you so much. A very, very lovely end to the month. It is the end of the month, but also, how do you know? Because are you telling me now that in America, when you buy something on your credit card, your debit card, they outline the items on your bank statement? Because they don't do that in Canada. They don't do that at all. Now, that's not to say that that information is not discernible, but especially in America, where if I'm not mistaken, can't you buy alcohol in locations where you can purchase other items? Like, you could go to a convenience store and buy pop, and they also sell beer. So it's confusing to me. Did they just find 4 where there was just liquor? Also, he's an adult. There probably isn't a prohibition on the purchase of alcohol. I think that there's a prohibition on consumption of alcohol prior to the minor child being in his possession, and therefore triggering a breathalyzer response. But he could buy alcohol for somebody else, ostensibly. And why would that be in anybody's business on the other side of the table here? I guess my mind just thinks a bit like a lawyer. Like, why the fuck is this even the point? The point is the breathalyzer. Has the breathalyzer been abided with? Has it been flagged? Then let's talk.
Your Honor, I'm sorry, but I'm going to object to any reading of bank statements into the record and any supposition that that was a purchase of alcohol. This is not an evidentiary hearing, and this appears to be attempting to sway the court to make favorable findings to the respondent without actually putting on evidence.
I'm not going to do any modifications. I'm just letting him argue. I want a very clear picture of what the actual argument that they believe that they can prove up is. So go ahead and finish. I'm not wanting you to elaborate too much, but I think you are being very particular as to what you believe you know now that you didn't know then. Go ahead.
Yes, and that's the
Not accepting it as evidence.
certainly, and I understand. I do, just for some records that today, I understand there's lots frustration with the allotment of exhibits we had yesterday. My anticipation was, from reading the prior email from the court, this was the proverbial push money where your mouth is. This motion's on file. I want to know what you got. Because I'm going to look at it, pursuant to KSA 233219. So that's why I took the steps to do it. Regardless, I won't get into much detail. There were alcohol purchases in December. There's actually alcohol purchases that date through a lot of 2024 on these bank records that we had provided. Just regardless, those are that's the concern with respect to those. More importantly, back to what we got a little sidetracked on from about 5-10 minutes ago. The 2 positive breath tests on the interlock device, I think, are more concerned because, pursuant to Ms. Langworthy's recommendation that's been adopted on a second violation, the recommendation is and this is where I think it makes the court's decision on whether or not we've met a prima facie case to bring anything forward with this motion. But on a second offense, the petitioner's parenting time is to be suspended until further order of the court. And so we've got two of those. We've got two of those documented. And so looking at this as far as, res judicata, tell me why the things have changed or why it's something different when we had an agreement not even a year ago with respect to residency and parenting time. It's as the court's already noted, none of this information was available at that time. And two, petitioner by his own actions has violated Ms. Langworthy's recommendation to the extent that her recommendation would suspend his time until the court made a further order. And so that just being the main focus, and I do understand, Your Honor, there are other issues that are pointed out in our motion. Some of those are for context purposes. I wholly understand and frankly agree. Things that occur prior to an agreement on parenting time really are not that relevant for purposes of where we are today. I do think they provide a little bit of context. And again, it took a little bit extra time drafting such a lengthy motion because I was anticipating we would be having this conversation or type of hearing today where again, the court's going to go, why in the hell, excuse my language, am I going to open this back up or do anything with residency and parenting? So there have been some other communication issues between the parties, again, that we've alleged in our verified motion. One issue that I also think is important that the court needs to know is that in May of, I believe it was this year, there was the petitioner was involved in a car accident, or perhaps it was 2024. I'm sorry. So regardless, there was a prior car accident in May of 2024 that is a little bit more concerning now. Well,
And did you already talk about it? Sorry, this guy talks way too much. Muskrat, muskrat, muskrat.
Because given the fact that there are some alcohol purchases in or around the time that the petitioner would have been in that car accident, the minor child was riding with him. And so it has been and still continues to be a very big concern for my client that petitioner is driving the minor child while he has work.
Sir Philip, thank you so much for 9 months of support and for recognizing that. I appreciate that. I appreciate it and thank you so much. I'm here. We're going to do it. We're keep on going. It's been 2 years. We got many more to come, babies. I love you all.
Or previously has or is drinking. Again, I'm not going to sit here and tell the court that I know or the exact science behind how alcohol dissipates in your system, but having a 0.068 breath reading at 6:30 in the morning would indicate to me, because obviously the body would have metabolized some alcohol from the previous night, that there was probably
Like a
some
brand new
fairly
bra.
decent or
Adam,
heavy
thank
drinking being done, at least on that particular occasion. And so we have the main records through December of 2024. If I had to speculate, there's probably going to be more on there if we had them through current. But that is the proverbial gist on the major issue and concern that we have, Your Honor. And again, as part of our motion, we've asked for a guardian ad litem to be appointed. I understand the court's position on domestic conciliation as well. The one thing I would also note, just for a clarification, that and again, this was my understanding of it. I was not the attorney of record at the time, but when the parties were originally referred to Miss Langworthy, which I think was maybe around March or April of 2024.
16 months, Bill. Thank you so much. Sweet 16. I love it. That is insane. Actually, it's insane to me how the time flies. As we fly under YouTube Daddy's radar. Thank you, thank you, thank you. Thank you so much.
Presentation at that time made, or the parties had already agreed, quote unquote, to the shared schedule. And during the domestic conciliation process, my client had some current concerns that she wanted to voice to Ms. Langworthy about having the shared schedule. And Ms. Langworthy said, well, hey, look, I understand your concerns, but the order from the court does not allow me to look at that. I had specific orders as to what my purpose is with particulars for this case, and residency and parenting time are not one of them. So Again, for purposes of this hearing, I do think it is relevant when the court's looking at this, whether or not we have met a prima facie case, looking at prior facts and whether or not there's I think it's arguable whether or not we've got to show material change of circumstance. I think the court was mentioning that initially. This wasn't, again, based on my understanding and looking at the court pleadings, the August hearing date was not a full-blown evidentiary hearing where the court heard witnesses' testimony and then made findings of fact and conclusions of law. So arguably, I don't think we even have to meet that standard in order for this motion to move forward. Regardless, if the court still wants to look at it, which is why I drafted the motion the way I did, there should be a material change of circumstance. I think we've absolutely met that threshold standard. But again, in the context of that, Ms. Langworthy's recommendation, arguably, or her purpose, the initial appointment time didn't really even deal with residency and parenting time. It dealt with more of some of these other parameters that she had set out for the petitioner to alleviate concerns of my client before his parenting time and driving the minor child and so on and so forth. So I think that's also relevant that there's not been a domestic conciliator who has been appointed to look at residency and parenting time issues specifically.
Oh, I love it. For a pre-roll, consume it for you. I will, my dear. I will indeed. Also, my hair looks like... Okay, so I tried something yesterday with it. It's definitely given it some more texture, I guess you could call this. I don't know. $5. Yeah, you can get a pre-roll. You can get 2 pre-rolls for like... You can get weed for cheap here now. Legal weed. An ounce of legal weed is $100 for decent weed. I only buy the $100 ones because I don't have enough money. Anyways, but it's actually got some texture, and that's because I didn't shampoo it. I only conditioned it, but I put the conditioner in when it was dry, so it doesn't feel very good, to be honest. But you know, it smells good. Does smell good. Thanks again, Nabil.
Because that was not within the purview of Ms. Langworthy in the previous time that she dealt with these parties. So again, Your Honor, with the access that we've had to the information that we've obtained, the fact that, again, per the ODC recommendation, frankly, petitioner's parenting time very well should have been suspended until further order of the court. Per that recommendation, I believe that we have very much met the standard of a material change of circumstance. We're absolutely asking that the court refer this case out. Again, our preference would be for a guardian ad litem. I understand where the court is at. We had asked for Ms. Campbell as a guardian ad litem if the court's inclined. Obviously, the court's going to do what it wants to do with domestic conciliation of Ms. Langworthy. But regardless, something needs to be done because we do have a 6-year-old girl here that is potentially getting transported with somebody that's maybe under the influence. And I know it's a very, very big concern for my client, amongst all of some of the other continued communication issues and whatnot that the parties had that I haven't gotten into a lot of detail to.
All right, Ms. Locke.
Thank you,
Miss
Your
Locke,
Honor.
before you get
So,
started, I
I
want to
would
say
like-
hi to Miss Donna. Okay? She came in here so nice. Hi, Miss Donna, Orlando Chiquita. How is the weather in Orlando today? Oh, dreaming of Florida. And Prudence did get her pretzel. Thank you for asking, Bill. Oh, it's hot, hot, hot. I hit a button there. I think we're okay, but I did hit a button with my phone. I was just about to boast about the temperature today because I know it's really like one of the perks of living here and spending so much money on living here that it is currently 67 degrees today, a high of 72, and the humidity is pretty high today, 61%. I know. How will I survive? How will I survive? That's true, Bill. I do make a profession pushing buttons.
Like to operate in fact for a moment, and that would be just a look at the record. And that's what I provided the court. My understanding of this hearing was that we were to establish with the court why there should not be any further consideration of this motion.
Streamlabs, you are killing me, bro. Why didn't it pop up? Oh, thank you, Miss Donna, for the #1 fan. You are my #1 fan, buddy. The pear. It's a pear. And it popped up here, pear character jumping up and down saying #1 fan. But why, Streamlabs? Why do you do this to me? Do. Thank you so much. Also, I really need to shut up.
And whether or not this even needed to be set for a pretrial. What I provided in our Exhibit 1, which was kindly provided pursuant to the court's guidelines on when exhibits have to be provided, is just a timeline of events that have occurred in this case. So while I appreciate Mr. Olson's rendition, it is not completely accurate. So the parties were ordered to DC, and Ms. Langworthy issued, and they were ordered to DC in 2023. They participated in DC, and Ms. Langworthy issued her report in February of 2028. Report and recommendations were filed with the court. Ms. Warren, her counsel at that time requested modifications to the recommendations and asked the court to review the recommendations. They filed a motion in March 19th. We filed a response, including exhibits that essentially what my client repeatedly says is debunked the accusations that were made in that motion to review the recommendations. The court had an in-person hearing on May 2nd on this case to review the respondents' objections to the recommendations. At that in-person hearing, everyone was prepared to provide evidence, to have testimony. The court took the case up by proffer, and the court did make modifications to the recommendations. I was ordered to draft that journal entry. I drafted it, sent it to respondents' counsel, and then there was no response. Ultimately, the court had to have a hearing on the journal entry. During this time, discovery is open. We're proceeding on the case. But the journal entry resulting from that May 2nd hearing was not resolved until the pretrial conference on August 1st. Not as a result of anything that either of the parties were doing, but simply as a result of respondents for our counsel refusing to participate in adopting the journal entry. From May 10th until August 1st, the parties were
Well, we don't know for sure that she didn't give him authority, that she didn't like what he was doing or failed to do or didn't get records, or she didn't like the direction things were going, and she objected to him signing off on the journal entry. I mean, we don't know that it was just he dug his heels in and just wouldn't finish his job. But go ahead.
The journal entry itself stemmed from the hearing. So there was no ability to say, we can't record what happened at the hearing. It was the language that was being used about how to define a caregiver that was the objection. That resulted in this delay from May to August on the parenting plan journal entry, essentially the adoption of the DC recommendation. However, the parties followed the recommendation during that entire time. We had a pretrial conference on August 1st. That was a hearing before the court. No issues were raised about the DC recommendation or report. And more importantly, neither pretrial questionnaire contained any concerns about parenting time. During the same period of time, this allegedly horrific, which it is not, car accident occurred, again, not raised in any of the pleadings, not addressed in any of the pretrial. After the pretrial order is issued, we have a change of counsel that occurred. So the trial date got pushed out. We were supposed to go to trial on this case at the end of October or the beginning of November. There was a new trial date set on November 5th. We were before the court for a status conference. Again, no concerns about parenting time raised. The court can make decisions in the best interest of the child at any time, yet we were before the court, no concerns are brought up. Then we were before the court again on a motion to compel discovery that occurred on December 11th. No issues brought up about parenting time. Then we had an in-person trial in January. No issues about parenting time addressed, with the exception of a few requested modifications of the parenting plan, including international travel and notification for international travel, as well as what countries the child would be allowed to travel to. We filed the journal entry. There's an objection to the journal entry and the contents. So we had another hearing with the court on April 11th. That period of time is significant because from January to April, the records were produced that are being addressed here. All of these records were made available, the interlock records, the bank statements, yet at our hearing before the court on April 11th, there is no mention about any issue with parenting time. The only discussion of parenting time in a hearing before the court is whether or not the child will be allowed to travel to Africa. That was essentially one of the biggest issues that we dealt with on that date. In addition to the things Mr. Olson mentioned, including parenting or child insurance, or child support, those items. So we've been before the court 7 times since the DC recommendation. Once about the DC recommendation, and parenting time, custody, residency has not been addressed other than the minor changes, despite the allegations that during this entire time, all these issues have been arising. So that's our concern number one, is if this was a big deal, it should have been addressed previously. The second concern of ours is in the DC recommendation, Ms. Langworthy's statements on page 3 of the recommendation. This is section 5, paragraph B. It specifically states that father has to maintain an interlock device in his vehicle for a period of 6 months, beginning immediately upon filing the DC reconciliation report and recommendation. My interpretation of that was it happened immediately upon her filing that with the court. As a reminder, at this point, my client had already had an interlock in his car voluntarily since August. So he had already had the interlock for 6 months, and Ms. Langworthy was saying he needs to have it for another 6 months. And then after that 6 months, he moves to a handheld breathalyzer. Her report specifically says immediately upon filing the DC report and recommendation. That happened in February. We agree that the court did not formally adopt the recommendation by an order until August 1st, but as we discussed here today, that timeline was skewed not as a result of an objection to the interlock, but as a result of an objection to the definition of a caregiver. So that's one concern. The other concern is there is a built-in remedy for the respondent. There's a built-in remedy in the DC report, and she chose for 18 months now not to use that remedy if she had concerns. We believe that if we went to evidence on this, it would show that my client is not in violation of her recommendation. However, even if he had been, she elected for 18 months not to use her remedy, and instead her suggested remedy is that my client go from equal parenting time to no overnights. That's not a remedy proposed by Ms. Langworthy, and it's not the step that was proposed and agreed to by the parties. The respondent has never elected to use the remedy provided by Ms. Langworthy. Instead, her goal is to go back to court and get what is arguably, I mean, for sure, not in the best interest of the child, to completely eliminate my client's overnight parenting time and parenting time in general.
Remind me what her remedy was. This is about the thickest file that I've got pending right now.
So, Your Honor, in that same paragraph that I was just reading from, during his parenting time, the father must test each time he drives his vehicle at a minimum 2 times per day, once in between the hours of 5 a.m. and 10 a.m., and once in between the hours of 5 p.m. and 10 p.m. So this was essentially during his parenting time, he has to test if he's going to have parenting time that day. If father has blown a BAC of 0 each time he utilizes during his parenting time, then we move on to the next step. However, if he fails, let's see. Should father miss a window for testing? So this is subparagraph F. It's on the following page, page 4. Mother will be allowed to immediately pick up the minor child from the father's care. So if he missed or failed a test, which she's getting the videos of these, then she gets to immediately pick up the child, and my client's parenting time does not recommence until he has a clean UA. So it's not another breathalyzer test, but it's a clean UA and a breathalyzer test when his parenting time is going to start again. She never elected that remedy. She never said, hey, you failed to send a video, I'm coming to pick up Isabel.
Okay. All right. Remedy. All right.
So our
And I
concern-
suppose there could have been a contempt of court, potentially as well. Amy, I know that we had a case similar concerns of alcohol where we blacked everything out, but gave them Ms. Langworthy's sort of stair-step alcohol conditions because they, as I indicated, some of the most technical, thorough, progressive requirements that I've seen. I mean, they are fairly strenuous, and certainly they were agreed to by these parties, and in another case I had, they were warranted. And I think sometimes I keep the recommendations separate. Well, I do in a separate file that I don't have here, but they should have been journalized. And I'm looking, I think we pulled them out to copy them, and hopefully we got them back into the file, but I'm not finding them. So can somebody give me a filing date? Or Amy, can you tell me where you think I might be able to find her report?
Judge, that report was in one of the notebooks that was supplied by one of the attorneys on this case. I do know that.
Yeah, it's exhibit E, Your Honor, mine. Sorry to interrupt you, Amy.
Okay, thank you.
But I think you've summarized. I just wanted to look. There we go. Well, it's not as long as the report as I thought.
And it's on page 4 of 6 or page 65, Your Honor. I believe
Yeah.
the provision Ms. Locke's referred to.
Okay. All right. Okay. Well, I'm still back to where I was in the beginning, which is I am inclined to refer this case to Ms. Langworthy for review to see if there have been any violations, and also whether or not in her view there's been anything that meets the basic threshold of warranting a relook at custody. Those two things. I also have considered, but I've got to look at the statute again. Her being assigned as a case manager. I think these parties, if they don't qualify right now, they're going to need a case manager.
I think they would qualify if the courts, but the only thing I don't know, Your Honor, is whether or not Ms. Langworthy does case management.
We checked with her to see if she'd take this case back.
Okay.
Just to
Okay.
begin with. And I think Amy asked her, do you do case management? But I'm not sure. I didn't call her and talk to her. I didn't want to talk to her about this case, independent of counsel, but Amy,
I did specifically ask with regard to case management. Her response was, yes, I would be willing to serve as case manager for these parties should it be ordered.
okay. All right. One of the
These people need more than a fucking case manager.
3508B, but it doesn't quote it. I'm sure you guys probably know it by heart, but I don't.
They need to stop litigating and start living.
3508B. I know one thing is successive motions, but I'm not sure it needs that. Yet, maybe we need one more motion is all.
Do the locomotion with me. That's what the judge does because she's a lawyer. Lawyers love to litigate. No offense. Most of them do. Yeah, that's how I feel too, Judge. This is in an hour. A full billable hour. Can you imagine is that worth more? Is that worth like 3 hours when you have to spend a whole hour in court? So your brain is like focused on court. So I'm gonna have to charge extra because I can't even focus on other shit.
Cases in which case management is appropriate shall include one or more of the following circumstances. Private or public neutral dispute resolution services have been tried and failed to resolve the disputes. Other neutral services have been determined to be inappropriate for the family. Repetitive conflict occurs within the family as evidenced by the filing of at least 2 motions in a 6-month period for enforcement, modification, or change of residency, visitation, parenting time, or custody, which are denied by the court. And I think this is the first actual motion, and it has been within 6 months of the decree, correct? Look at your timeline.
Yes, yes, Your Honor.
Yes,
Okay.
Your Honor.
We don't have 2 successive motions. A parent exhibits diminished capacity to parent. If the court or hearing officer orders case management under subsection A, the court or hearing officer shall appoint a case manager taking into consideration the following. So,
Your Honor, if they went back to Miss Langworthy for DC to resolve the
yes,
existing issues, could she make a recommendation to the court as to whether or not she thought case management was appropriate for the next step?
possibly. I mean, I think it still's got to meet the statute. So I'd have to kind of figure that out.
At that point, they would have gone to a neutral dispute resolution service twice with Miss Langworthy,
Yeah, I would agree.
which would be B1.
Okay. Yes. I can't imagine her saying not, but maybe. So
The
maybe
other
these
case I got
parties
this
will
morning
call it
was
truce,
even
but I'll tell you
worse.
what, I know you understand this, Miss Locke. There's certain buzzwords and there's certain things that come up that the court can't make mistakes on. And that's issues of safety. And that generally involves alcohol and potential drug use or physical or sexual abuse. So those are the words that make me extremely nervous about
they get me
making
banned,
wrong
Judge.
decisions and having a bad outcome, as you well know, as any attorney knows. However, I have a lot of faith really in Ms. Langworthy in the way in which she worked with these parties and the way in which she crafted her report and recommendations. And so I wanted to go back to her, and I'm going to ask Ms. Locke that you prepare the order as DC, but I want specifically her to look at, has there been a violation of the original recommendation or orders of the court? Does it appear that there are circumstances that have evolved since her report and or the final hearing, and give her a copy of your Exhibit 1 because she understands the law in that regard, that even
Courtney.
meet the threshold of reconsideration of custody? And does she believe this is a case for case management? And obviously, I have to be the final arbitrator. So, but I would like some opinions from her. And then we can still litigate the issue of, is the court even going to reopen the matter for custody litigation?
Your Honor, in our responsive pleading, we had a section requesting a return to DC and outlined several parenting concerns that my client has. Is it appropriate to ask Ms. Langworthy to also review his specific concerns, or are we going back solely on the respondent's concerns?
I think the basic questions have to be answered first. And then if she's recommending case management and I deny reopening of custody litigation, then they can go to her for case management for any concerns they have.
Understood.
So I think that's the avenue. I don't want to get this too convoluted. I want this to be pretty succinct. I almost would like you two to get a transcript of your arguments today, a transcript of this hearing, although, well, we don't have a court reporter, but it would be kind of nice if she just, all she would really need is your motions, the transcript of the hearing, and some limited exhibits. But
Judge, my concern about the transcript of the hearing is the things that were stated on the record, which we obviously believe are not true, would
okay.
be crossed as.
Okay. All right. Well, then I guess we leave it as, do you guys want it to just be nothing? She gets nothing but talk to the parties? Or do you want, and you have to let her know if she can do any independent investigating and of matters, which, you know, I would want her to look at the exhibit. She would need to look at the exhibits.
Yes.
So
Yeah,
I suppose what it should be is their motion, their exhibits, your response, and your exhibits.
But Judge, we weren't given, my understanding of the court's position today was what we provided in Exhibit 1, which was just an outline of why the case shouldn't even go forward. We didn't provide exhibits countering their exhibits, frankly, because I got their exhibits yesterday and I didn't anticipate that would be the case. My preference would be if Ms. Langworthy spoke with the parties and believed she needed additional information, that she could reach out to Mr. Olson and I, and then we could then provide those things to her.
Okay, but I can't let her have your exhibit 1 and nothing from him.
But the only thing I would say is that it may cut down on time if we could give, I mean, I don't anticipate we would have anything more than the exhibit notebook that we provided today, Your Honor. Obviously understand Ms. Locke's gonna want the opportunity to provide information as well. I was gonna do whatever the court says, but I'm just assuming Ms. Langworthy's gonna talk to the parties and then want the exhibit. So if we could head it off and send them to her up front anyway, I'd be fine. If Ms. Locke wants to put some exhibits together and send them, I don't think that's an issue for me, but.
I'm gonna let her have the benefit of the motion, and we will forward our copy of the exhibits, or you come get them, Mr. Olson.
Yes, ma'am.
Have them
Yeah,
delivered to her, and Ms. Locke, if you could send her a copy of your exhibits. I do think she needs to look at this documentation that they claim they got after her recommendations, and after I know you said there's a time period in there from January to April where they could have been reviewed and brought up, but it is possible that she didn't sit down with them until after. Those AHA documents, I think she needs to look at and say, are these AHA documents, or can they be explained? Or are they even indicative of anything? I really do want some of her opinions. If you want to continue to litigate it, I guess we can through counsel, but I want some overview opinion from her on whether or not she thinks there's been any direct violations, and whether or not there's any evidence that's indicating that there's violations or should be consideration by the court of modifications. So that's the best way. I mean, to have her look at things and statements and mom referencing documents that she says she's now gotten a hold of and studied and seen, and then Paula not to have those, I don't think that we can end this thing once and for all. And I do want a line in the sand. I do want to end this thing with a line in the sand, because then it starts becoming an issue of parents just not being willing to co-parent. And that's a different matter altogether than what's in the child's best interest. So, okay.
are you,
think-
Judge?
Yes.
Sorry to interrupt you. Since your stuff next Thursday, are you okay if I wait to pick that stuff up Thursday, or would you prefer to have me send somebody out? Because I would check with Paul's availability, but as far as
I'll just
Okay.
let you and your
Okay.
staff figure it out through Amy.
Okay,
And
sounds
I'll
good.
put it back on the desk. I
Your
haven't.
Honor.
even gone- Yes.
Sorry, I didn't mean to interrupt.
No.
So can I provide exhibits or no? Just
Yes.
our one exhibit, or do I get to provide additional exhibits that we would have presented had we taken evidence?
Yes. You're
Okay,
gonna provide those.
okay.
Yeah. I just didn't want to make you have to give me a copy that I'm not going to look at right now. If you wanted to just, for expense wise, just do one to her, and then you can give it to me at a later date if we have to schedule something, or if we end up in some kind of evidentiary hearing where you want to use them. That's all. If you want to do 2 copies and send one over to, well, I'm not even going to keep Mr. Olson's copy, and I haven't even looked at him. So really, actually, it'd be pretty fair across the board if you just send your exhibits directly to her. And then we can get them for her, for me, or you guys can duplicate it. I mean, whatever you want to do or your clients want to do, but I was just suggesting that this, just go ahead and go to Miss Langworthy in the form that it's in. And you have copies to look at, so you know what's being submitted by them to her.
Yes, Judge.
Okay, all right. Well, I hope that she can get you in, y'all in quick.
Would it be possible to set this for a status just so we have
Oh,
some
yeah.
benchmark?
Yes, good
for-
idea.
Yeah, I'm just trying to think. I was trying to think. I've had a couple of independent cases because of the the tuition hikes and all that kind of stuff. And so I was trying to think if there was, I was trying to think, is there any urgency to anything as it relates to anything? And I don't think we have any school issue or any issue. So I'm thinking 90 days probably. I hope she's concluded some things sooner than that, but I don't think 30 is enough.
Hmm.
So, okay, today's 31st. 1, 2, 3. So again, I think we're looking at the end of October. Amy, we set something special setting, the Vandeford case for the 27th of October, but that's a day
Yes.
before a jury trial.
It is.
On my calendar, what are there cases there you can look at that may very well go to jury, or can you tell?
Judge, we only have one case set there, and the guy is on bond currently. I'm sure we'll have other cases go there that'll be for plea stuff, but that's the only case we have set.
Right, or we could have, it's just July, we could have more juries set there.
Correct.
But
Correct.
let's go ahead and then and do this from at 10 o'clock, if that works for council, on Monday, October the 27th, 10 a.m.
It works for me.
Okay,
And
so
just book
Amy,
until like noon.
yes, we'll use 9 to noon for any domestic matters that we need scheduled. And then we'll do 1 to 5 for any pretrial stuff if we have a jury go.
Okay. Well, that takes up that entire morning between these two cases. So
Pretty much, unless you want to squeeze something in at 11:30 or something.
And this will be for status. Your Honor, I plan to reflect the date in the DC.
Yes,
Okay.
yes. But I'm gonna allot an hour because I always feel like we need an hour.
Well, you just took an hour.
And
All
Judge,
right.
I think you did say did you designate who was going to do an order for?
Yes, Miss
Paula?
Locke
Okay.
is.
Thank you.
Because the Supreme Court rule, sometimes I don't think we're as careful as we should be. The Supreme Court rule really does require that you give guidance to DC on what they can and can't do and what they are and aren't looking at. And Miss Langworthy's familiar enough that she acknowledges where her limits are. And so I think that we need an order that's not just some form that's real general, that doesn't give her a direction based on where we're at with this case. Okay, sounds good. If there's nothing
Thank you.
further today, we are adjourned. If there's a hiccup or something with anything, let me know.
Thank you, Your Honor.
And that was all they were. Oh, looks terrible here. Anyways, you guys, we made it through. I wanted to say to Shane, remember there are some ways that you can download videos to watch later on YouTube. Like, so if you go to Wi-Fi, you can do that and then watch them later on at night. That's something to keep in mind to get you through the month. And then also, we'll miss you. Happy birthday to Josie. Again, I hope you have a great birthday. She's going live tonight at 5 Pacific time. Also, tonight is going to be the members only for Credence and Mikey. Mikey's going away tomorrow. So I don't think there will be slap fights, but I'm sure that you'll find something to do on Friday night. And guess what? We have a date on Saturday night together. That's right, you and me. Let's be the belles of the ball on Saturday nights, shall we all? He's going to a baseball game, Courtney. He's going to a baseball game. I think in DC. I might be wrong on that, but that's where I thought. Anyways, you guys, seriously, thank you so much for being here. That sounds boring. I love you guys so much. We're gonna have more fun together here anyways. He'll probably be, well, probably not, no. I'm sure he'll be watching a baseball game. But we will be tuned in to court around here. And tomorrow night is John's gaming stream. Don't forget that as well. Do me a favor. Remember that I love you. Except for you, green screen. Today I don't love you. You've been pissing me off today. But I love you. And I'm proud of you. And I will see you in the next video. Okay, bye.